Well, I am going to go ahead and officially kick us off. So welcome everyone to our webinar on rebates, gifts, and inducements. I'm Glenda, the director of the KICKed program, which is our educational and training services. And these webinars are just one of the options that we make available as part of the program. Now, I want to let everyone know that at the end of the webinar, I do have a special offer for all of you for our in-depth 50-state research survey, and that's up and available right now at education.currentcompliance.com. You should see a link in your sidebar, and you can click on that. It'll open a new tab, and you can see more about the survey. But I'll be speaking about it later at the end of the webinar and going over the special offer that we have for you. So for today's session, it's presented by our Research and Compliance Associate, Kaycie Tyll. And she really has put together some useful information to help compliance professionals and others that are thinking about compliance aspects of sales and inducements, just to really help think through what the issues are and how to evaluate ideas that you may have or that you may be asked about. So with that, I'm going to pass it over to Kaycie.
Thanks, Glenda. And again, welcome to the Current Compliance Services webinar, Sales Inducements, More Than Just a Free Meal. We know you're all busy and we appreciate you taking the time today to join us. The webinar we have planned for you today should last about 20 to 30 minutes. So let's get started. The agenda for today can be broken down into 5 separate sections, and we start off by asking ourselves the questions: what is rebating? What insurance regulations are out there? And who is subject to these regulations? After answering those questions, we'll discuss 5 key things that should be taken into consideration before promoting such offers, and we'll also take a look at a few case studies to see how the rules and regulations might apply to specific situations. And finally, we'll go over several enforcement actions to see how specific violations were dealt with and what repercussions there were to be faced. Unfortunately, given the specific nature of this type of content, we won't be able to end with a live opportunity for you to ask questions, but we will provide you with my contact information. So if any questions do arise, you can reach out directly to me. When we look at the insurance regulations that are out there, we find guidance in a number of places regarding gifting and rebating. The issue is dealt with on a broad scale in the NAIC Model Unfair Trade Practices Act and is also adopted and interpreted to varying degrees among the states. A question you may find yourself asking is, at what point do the limits lie? This is something we'll explore a bit later, and not only do the state statutes help provide us with this guidance to begin answering the question, but bulletins and memorandums do as well, giving us insight into the department's interpretation of their own rule. There are also some prohibitions that are imposed by insurance carriers, which may be more or less stringent than those imposed by the states. It's important to be aware of these limitations, especially concerning gifting, rebating, or sales inducement practices that occur in Florida and California, which are 2 states that don't outright prohibit such practices. This could mean that while these 2 states allow these practices to occur, certain carriers may prohibit them, so it's important to be sure of the expectations that are set by the carriers of the products you sell before engaging in any such behaviors. So, now that we know a bit about what type of regulatory material there is, we come to the question of who is subject to these regulations. Insurance agents, insurance companies, and marketing intermediaries are among those who should be aware and familiar of these rules. The NAIC Model Regulation 880, or the Unfair Trade Practices Act, was written with the purpose of regulating trade practices in the business of insurance by defining or providing for the determination of all such practices that constitute unfair methods of competition or unfair or deceptive acts or practices, and by prohibiting the trade practices so defined or determined. The Act also states that if not specified in the contract, paying, allowing, giving, or offering any of the following will be considered an unfair or deceptive act: rebates of the premiums payable on the policy, special favors or advantages in the dividends or other benefits, any valuable consideration or inducement, or giving, selling, purchasing, or offering as an inducement any stocks, bonds, or other securities, any dividends or profits accrued, or anything of value. A majority of states have adopted some variation of the model regulations to provide guidance on what practices are allowable in their state. Only a little more than a dozen of these states stop there. Many also include further, more detailed definitions and guidance on gifting, rebating, and sales inducements. Why is that? Thinking back to that bulleted list of unfair or deceptive acts, one of them was pretty broad. Any valuable consideration or inducement. What does that mean? How should it be interpreted? And how can one know what would be included as a valuable consideration or as an inducement? In a memorandum issued in 2013, the Commissioner of Montana interpreted valuable consideration as an amount greater than $25 received per person per year, and the Commissioner also relies on a two-part test to determine whether or not something is rebating under the statute. The first part of the test is the requirement that the consideration be valued under $25, and the second part of the test is that the consideration be universally available. If the consideration does not meet both parts of this test, then it is considered a rebate and is not allowed in the state of Montana. The second part of the test is key, and it's something that we'll be revisiting shortly, as it's something that remains consistent among the states, so keep it in the back of your mind. The first part, however, the nominal value limitation, is one that is specific to Montana. There are a number of other states that provide a limitation, although the amount may differ. Ohio, for instance, is a state that permits meals with a fair market value of up to $50 as long as that meal is not provided upon the condition that a policy be purchased. In addition to varying rules on monetary limitations, there are other ways state rules are varied as well. Commission statutes may come into play. For some states, such as Washington, Alabama, and Georgia, this is referring to commissions earned by licensed professionals. In other states, like Kentucky, Pennsylvania, and West Virginia, these statutes are focused on referrals earned by people who are not licensed, like customers, instead. And it's important to note that lottery and gambling laws may also be applicable. And even if there are state-specific statutes included in these insurance regulations, there could be laws outside of the insurance realm to be aware of as well. Now that we have a bit of a background about what types of regulations there are and who should be mindful of them, let's go ahead and take a deeper look at the considerations that can make an inducement an inducement. It can be hard to make an estimated guess about whether or not something would be considered a sales inducement or rebating in any given state. There are just too many variables, too many differences in rules and regulations among the states. It's really a stab in the dark that could end up getting you into hot water with the state, which is why not doing your research beforehand is never a good idea. However, with that being said, there are 5 key things to consider that can help you make a determination one way or the other. Would receiving this item, meal, offer, etc. be something that could encourage someone to make the purchase? Has something of value been given, paid for, allowed, or offered that was not included in the contract? Is there a raffle, lottery, or other game of chance involved? If so, as we already mentioned, gambling and lottery laws for the state must be taken into consideration. Is the offer available to the general public, or is it limited in some capacity? Maybe it's only available to previous customers or to those who have obtained a quote. And finally, what is being offered? A gift card, a meal at a high-priced restaurant, a promotional item such as a calendar, pen, or tote bag? If the answer is yes to any of the first 3 questions, then chances are it would be considered a sales inducement or rebate. And if this is the case, depending on the answers to the last 2 questions and how they compare to the rules and regulations of the particular state or states involved, it may or may not be allowable. As we said a moment ago, you should be sure to do your homework beforehand. Having a handle on each state's position can help to keep you out of trouble with regulators. Let's take a look at a couple case studies together to see how the rules play out in real-life scenarios. We'll take a few moments for a brief survey to see what your initial thoughts are about each case study and then discuss the state's rules and regulations that are applicable to make a determination on whether or not the act or the gift is considered to be a sales inducement. Case study number 1, Go Paperless Offer. In Arizona, an insurer pushes an ad to their current clients offering a $100 gift card for providing feedback, through an independent third party about their products and services. Is this considered a gift, rebate, or sales inducement? Take a moment here to make your selection in the poll on screen. If either yes, it is, and what's being offered is problematic, no, it isn't a gift, rebate, or sales inducement, or yes, but it's okay because an allowable amount is being offered. According to Section 20-452 of Title 20, Chapter 6 of Arizona statutes, it's not prohibited for an insurer to retain a third party to conduct a customer feedback effort that's meant to help the insurer improve the quality of its products or services, nor is it prohibited to offer an incentive up to $200 to provide such feedback. The caveat, however, is that the incentive or feedback effort cannot be in connection with the application for or renewal of insurance coverage. So, based on these rules, the offer of a $100 gift card is not considered a gift, rebate, or sales inducement and is allowed. With that being said, the insurance department may look more closely at this type of offer depending on timing and circumstances. If it is being provided to customers whose policies are nearing renewal, odds are it will receive more attention and more scrutiny than if not. Case study number 2, refer a friend. An agent in West Virginia wants to pay their clients $20 for every referral they give that successfully writes business. Is this considered a gift, rebate, or sales inducement? Take another moment to make your selection in the poll on screen. If either yes, it is, and what's being offered is problematic, no, it isn't a gift, rebate, or sales inducement, or yes, but it's okay because an allowable amount is being offered. As per Section 4 of Title 114-70 of the West Virginia Code, a one-time fee of $25 or less is allowed to be provided as a referral, but payment of a referral cannot depend on the sale or issuance of an insurance product. So the answer to our question is yes, this is rebating, and no, it's not allowed. Can the agent restructure this offer in a way that would make it acceptable? Yeah. The agent could offer their clients a one-time $20 fee for providing a referral, whether that referral was successful or not. Now, it's important to note that other issues aside from those surrounding gifting and rebating could arise from having clients provide you with referrals. Remember, unlicensed persons have to be careful of the content of conversations that are had. This means they cannot act as a salesperson, nor can they discuss specific policy terms and conditions as a means of promotion. Be sure that if you offer a referral program to your clients, you chat with them about the do's and the don'ts beforehand. Case study number 3, select client dinner event. 10 large clients in the state of Texas have policies set to renew in 2 weeks and are invited to a fine dining outing by their insurance agent. Is this considered a gift, rebate, or sales inducement? Take a moment here to make your selection in the poll on screen. If either yes, it is, and what's being offered is problematic, no, it isn't a gift, rebate, or sales inducement, or yes, but it's okay because an allowable amount is being offered. According to Texas Code Section 541.058, advertising items, educational items, or a traditional courtesy commonly extended to consumers that is valued at $25 or less is not considered a rebate or inducement. While it's fair to include the offer of free lunch or dinner as a traditional courtesy, the value of the meal must meet the criteria of that $25 limit. So odds are, unless the meal is prefixed, a fine dining outing could push that limit, which would then make it an inducement. Lee Loftus, Governmental Affairs Director for the Independent Insurance Agents of Texas, was interviewed by the Insurance Journal magazine back in 2014. In this interview, Loftus discussed the Texas Department of Insurance and their interpretation of the rules regarding gifting and rebating. He said the TDI looks closely at certain factors surrounding timing and circumstance when determining whether or not something would be considered an inducement and/or a rebate. So, while this may not be included in any Texas state rule or regulation, it should be some food for thought when creating these types of events. And you can rest assured that Texas isn't the only state considering timing and circumstances when making their determination about similar events. Now that we've taken a look at a few hypothetical situations, let's dig even deeper and look at a few enforcement actions to see what the consequences have been when these regulations were found to be violated. Agent Gary Erie co-sponsored a trip to a Minnesota Vikings game in 2011, and out of the 59 attendees, 21 were insurance customers of his. After calculations, it was determined that Mr. Erie had spent $97.86 per trip attendee. Mr. Erie also held a client appreciation dinner that same year, where the cost per plate was $52.52. North Dakota statutes state that anything over $50 per person spent on gifts, meals, entertainment activities, and the like is considered an inducement and is not allowed. For this reason, Mr. Erie received a 1-year conditional license, in addition to being fined $100 per violation, meaning one violation for each trip attendee and each dinner guest, even though the cost per plate was only $2.52 over the limit. This is just one reason why it's important to calculate the cost of the amount spent per person when putting together customer appreciation events and even informational seminars, and why it's also important to keep receipts and documentation verifying that you did not go over whatever monetary limit is set, if one is set, by the state or states involved. Agent Angela Wilkinson was investigated by the Florida Department of Financial Services for offering illegal inducements in the sale or solicitation of insurance products. In 2012, she used a third-party mailer that included an offer to receive a $100 restaurant gift card to any potential clients who met with her. Now, this is pretty cut and dry, as the Florida statute only allows gifts to be provided up to an amount of $25 per year. And in fact, Ms. Wilkinson agreed to a settlement stipulation in which she had to pay a $1,500 administrative penalty to the state. But what's interesting about this particular case is that Ms. Wilkinson wrote a letter to the state explaining that she had in fact done quite a bit of what she considered due diligence to ensure that the offer was allowable and compliant. In her letter, she stated that she referred to textbooks that she had used to prep for her 215 licensing exam. She searched the internet, and she even reached out to the marketing company that provided her with the mailer. Her contact with the marketing company, who presumably provided these mailers to agents licensed in other states besides Florida as well, told her that their attorney's judgment was that it was okay because the limit was $100 per year. Now, the point of this isn't to call out the marketing company for providing misinformation. The information could potentially have been provided without the realization that Florida statutes differ from whatever state statutes they may have been familiar with. Or maybe they didn't realize the rules are different surrounding the sale of insurance products than what they are for investment products, or really any other number of reasons. Instead, the point is to exemplify how difficult it can be to pinpoint information that's accurate for the state that you do business in, and why it's important to always have citations to back up any information provided to you, regardless of the source. An insurance agency, the Varney Agency of Maine, held 4 separate raffles at various events from 2012 to 2013 to promote their business. Each raffle was open to the general public at no cost. The prizes that were raffled off included a gas grill with a value of $200, a flat screen TV valued at $300, another flat screen TV valued at $400, and an iPad valued at $400. As per the information provided within Maine's life insurance regulations, raffles and drawings that have no participation cost to the entrants are allowed in the state, but any prize provided must be valued at no more than $100. The Varney Agency received 4 violations of exceeding the allowable raffle value limit and was fined $3,000. Maine is one state that happens to provide clear guidance about the conduct of raffles and drawings. Regardless of the state, even if gifting and rebating rules are provided within the context of insurance, we highly suggest due diligence be done and gambling laws be reviewed as well. This can help ensure that engaging in these types of activities are in fact allowable. This level of due diligence should be done elsewhere too. Keep in mind that advertising and licensing, among other areas that might be of concern, should be taken into consideration when deciphering what could be considered a sales inducement and when deciding what types of activities and promotions to engage in. Guidance on gifting and rebating can be challenging to find, and once you do find it, what's allowable and what isn't may not exactly be in black and white. It's true, rebating laws can be complex and subjective, and the laws provided can vary widely from state to state. All applicable regulations should be carefully evaluated, and sometimes this can include those outside of the scope of insurance. Seek professional guidance to help you navigate these rules. We here at CCS offer rebating research services, including our 50-state survey on gifts, rebates, and inducements that outlines the state's positions and includes citations for all information provided. Now that you understand some of the challenges of recognizing and evaluating a sales inducement, let us help you overcome them. Here's Glenda to give you a little bit more information about that survey.
Thanks, Kaycie. I hope everyone has a little bit better sense of the issues associated with rebating and thinking through how to evaluate different sales ideas that may include a rebate, gift, or inducement component. Now, as Kaycie talked about, there are a number of variations on a state-by-state basis on things like what's allowable or at what point something becomes unacceptable. And finding those nuances for each state and keeping track of them is a fairly big undertaking. That's why we prepared the 50-state research survey. It is designed to save you time from having to search for rules and regulations for all the states and U.S. territories, and it's intended to provide one central location where all that information is housed. Whenever it was available, we've gone beyond just the standard rebating laws and also included information from bulletins or circular letters, just whatever we could find to really give you a more comprehensive overview of what the standards are. The other time-saving benefit of the survey is that we maintain the information. That means anytime there's a change or an update or new information related to the topic, we're going to add it to the chart, and then we'll push out a notification to you letting you know that there's a new version available. We also include a revision history on the cover of every version that we put out, so you'll know exactly where the changes are. You don't have to spend time comparing an old version to a new version. You can just look right on the front page and know what's been changed. We also wanted to ask a couple other quick questions just related to research surveys. So the first question is, would you be interested in other 50-state research surveys on different topics besides rebating? We are just trying to get a better sense of what would help you most in your compliance work. So you can click yes or no for that one. All right, looks like we have some good responses. And then the next question is really which of the topics is of most interest to you. And we have several up here, so I'll just run through them really quickly. First is unclaimed property. Next, we have interest payable on death claims. Next is replacements. Next is annuity suitability. Next is filing for advertising, filing requirements for advertising, or you can select all of the above, or if none of these is the one that you most want, you can select none. And then if you are willing, I would love it if you could send me your suggestions directly. My email is gbean@currentcompliance.com, and we will definitely take that into consideration. All right, awesome. It looks like I'm getting some good responses. So thank you everyone for your time and feedback with that. I'm going to turn it back to Kaycie so she can wrap up.
Thanks, Glenda. And with that, we can go ahead and conclude today's webinar. We thank you again for taking the time to join us. As I mentioned before, if you have any questions, you're more than welcome to send them directly to me via email at ktyll@currentcompliance.com. You can also send me any feedback that you might have had on the webinar or any of the content that we discussed today. So once again, we just want to thank you for sharing your afternoon with us, and we hope to see you on the inside.